And I guess you notice 2 chairs rather than the usual 3 for this debate. One of the chairs is for me, and one of the chairs is for our debater, Elizabeth Price Foley. As most of you were informed, Glenn Greenwald sustained an injury that he will definitely survive. I know because I broke my ankle and I'm recovering still, but I too will definitely survive it. But it made it impossible for him to get on a plane from Brazil and fly up here. But we are most grateful to Glenn for consenting to do this debate. He will be at an advantage, so to speak, because you're going to see him larger than life on our big screen, even though I promise you, we had Glenn actually this past April, and he is no more than medium height. But I'm sure that Professor Foley will be able to deal with this monstrous look of her opponent, and we look forward to a lively debate. Again, the resolution reads, presidential immunity for official acts is a key factor in the proper functioning of the U.S. government's executive branch. Please vote yes, no, or undecided on the resolution, and your vote will only count if you vote now, and then you will vote after the debate ends, and whoever moves the needle in his or her favor will win the Tootsie Roll. We're grateful to the Smith Family Foundation for contributing hugely to these events. The ticket sales do help a bit, but they are way too little for us to run the expense of the debate and as well as the party afterwards. Without the Smith Family Foundation, most of this would not be possible, so thanks to them. We're also thankful to the Reason Foundation for handling all our administrative functions and for publishing our debates on video and on podcast on the Reason channel. And here to say a few words, Reason Editor-at-Large, Nick Gillespie.
I realize I'm tempting fate by walking anywhere around you, Gene, but I'm willing to take that chance. Thank you all for coming out. There are copies of Reason magazine scattered throughout the theater. Please take them, read them, share them with people. We are a 501c3 nonprofit, which means your contributions to our operations are tax deductible. If you're here because of the Soho Forum, please, you can donate at reason.com/donate and earmark it and say, hey, I like the Soho Forum, put it towards some of that. We're streaming tonight, right, Gene?
Yes.
We're live streaming, so welcome to all the people there. Welcome to Glenn Greenwald in Brazil. This is going to be a great debate, and I just want to say one of the reasons why Reason is so proud and happy to work with the Smith Family Foundation and with the Soho Forum is because Gene and Jane and the Soho Forum model the kind of debate that we need. It's informed, serious, entertaining, and fun, but it's civil again and again and again, and it's also willing to keep things going, to keep the conversation going when we're being shut down, whether by inclement weather or physical accidents or the government, time and time again, and even just tonight, improvising through this all has been great. Gene, you have kept this going. You kept it going through the pandemic, and you kept it going through, Trump's term, Biden's term, and Trump's second term, which brings us back to the question about presidential immunity. So thank you all for coming out. Thank you, Gene. Thank you, Soho Forum. And, of course, free Ross Ulbricht on the first day, right? So thank you very much.
Yeah, I'll have to do moderator's prerogative and say the same thing, free Ross Ulbricht on the same day. In fact, there are a couple of other people I'd also like him to free as well, but we have no time for that. Again, the resolution reads, presidential immunity for official acts is a key factor in the proper functioning of the U.S. government's executive branch. That's the first mission of the Soho Forum, to have a lively debate about an issue like that. As many of you know, the second mission is to build a community. Build a community of people who like to come to our debates and who like to come to our after parties. I trust that Professor Foley will be able to attend the after party. Glenn Greenwald unfortunately won't be able to make it. We wish he could. But the after party is hosted by my wife, Hisako, 2 blocks uptown from here. I'm sure that half of you know the address. Just follow the crowds or follow a crippled guy like me with a cane, and you'll find the address, 55 Great Jones Street, which is essentially just 2 blocks uptown from here. It's essentially 3rd Street. That's our after party. Do please come. Again, that's the resolution about presidential immunity, and defending the resolution is Professor Elizabeth Price Foley. Professor Foley, please come to the stage. Okay, and now, through the magic of technology, I hope my sit there, yeah. I hope that my technological wizards are ready. Glenn Greenwald, please appear on the screen. Glenn, you're looking great, and again, thank you so much for consenting to make this appearance despite the problem that you had. I assured everybody it's a problem that you'll survive, although it prevented you from getting on a plane, that's for sure. I know from personal experience, having also sustained a similar injury. Well, again, that's the resolution. We have it. And I want to ask Jane to please close the voting. Professor Foley, you have 17 and a half minutes to make the case. You can take the podium. Please take it away.
Thank you, everybody. Appreciate everyone coming out on a rainy night. I want to thank especially Reason Foundation, Smith Family Foundation, and of course Soho Forum for making all of this possible. And I want to thank Glenn, even though I know he's injured. I'm appreciative of the fact that he decided to soldier on and participate in what I hope is a fun, lively debate. Sure. Can everyone hear me okay? Okay, terrific. All right, with all my thanks aside, my husband said I had to open with a joke. I'm not much of a jokester. Well, I kind of am when I teach class, but so the only one I could come up with was, what did Liz Cheney say when she bumped into Joe Biden? Pardon me. Pardon me, thank you. I knew this was an intelligent crowd, so you'd get that one. It was originally, of course, a Gerald Ford, Richard Nixon joke, but I tried to update it. Okay, so since I'm taking the affirmative, I think the first thing I want to say is that there's really nothing particularly remarkable as a matter of constitutional law about the Supreme Court's decision this summer in Trump versus United States. As many of you know, despite the outcry, as many of you know, the court held in the Trump case that presidents are entitled to immunity for so-called official acts, which means acts that they take that fall within their Article II constitutional authority. And the reason I say it's not particularly remarkable is that in 1981, the Supreme Court decided a case called Fitzgerald versus Nixon, or Nixon versus Fitzgerald, depending on what appellate level you're talking about. But that was, almost 25 years ago. And in Fitzgerald, the court dealt with a civil suit. It was a civil suit brought by a guy named Fitzgerald who lost his job in the U.S. Civil Service when President Nixon decided to reorganize his job away, essentially. And so Mr. Fitzgerald filed this civil suit, and he claimed that Nixon had actually really fired him because he didn't like what Mr. Fitzgerald had said about cost overruns in a Department of Defense program, and he had basically been a whistleblower before Congress about these cost overruns. And it went all the way up to the Supreme Court, and the court held that because Mr. Nixon was the president at the time this action had been taken against Mr. Fitzgerald, he was entitled to immunity from the civil suit. And he was entitled to immunity because when Nixon reorganized away Mr. Fitzgerald's job, that was merely an exercise of his executive authority under Article 2 of the Constitution. So any official act that a president takes that is cloaked with the authority of Article 2 is immune under Nixon versus Fitzgerald. Now, the Fitzgerald court also gave us a rationale for the immunity, which was, I think, very important to understanding the Trump case this summer. And the rationale, said the Fitzgerald court, was horizontal separation of powers, right? Which is just the division of power between the three branches of the federal government. Article 1, the Congress; Article 2, the president; Article 3, the federal judiciary. And the court further said that there's something unique about the presidency. The presidency has two sort of unique different aspects to it that make that kind of separation of powers-based immunity even more compelling than it might be for the other branches. The first characteristic that the Fitzgerald court focused on was that the presidency is very different, unique from the other branches, because the Constitution vests all executive power in one person, the president, right? And that's very different from the other two branches because the congressional power, as we know, is wielded by 535 members of Congress. The federal judicial power under Article 3 of the Constitution is wielded by, at least at present, 870 different Article 3 federal judges. But the executive power, constitutionally speaking, is wielded only by the president alone. And you say to yourself, well, isn't it true that there's a bunch of people that work in the executive branch? Don't they wield executive power too? Well, yes, of course, there's lots and lots of officers of the United States that work for the executive branch as well as regular employees of the executive branch. But, and I call these people minions because I love Despicable Me. But these minions that work for the president, they don't wield power constitutionally independent of the president. The Supreme Court calls these minions the quote-unquote alter ego of the president. And they are accountable to the president alone as a matter of constitutional law. So despite what a lot of talking heads on TV constantly say, and it drives me crazy, executive agencies and departments are not independent from the president. They carry out executive power on his behalf, and he alone exercises that executive power under the Constitution. Another simple way of putting this is there is no fourth branch of government, right? The second aspect of Fitzgerald that made it decide that the president needed official acts immunity was that not only does the president wield all this power alone, but he has powers under Article 2 that are inherently discretionary and incredibly broad. So, for example, the president has the authority, actually has the duty, to faithfully execute all federal laws. And as you know, there's lots of federal laws out there, way too many of them if you look at the US Code. And almost every one of us in this room probably is violating one of those laws at some point, right? And so you have lots and lots of federal laws that affect lots and lots of people, but the president can't execute that law against all of us all the time. He has limited resources that get appropriated through Congress, and with limited resources, he has to exercise what's called prosecutorial discretion and decide, who to prosecute out of all the possible people he could prosecute. That is a highly discretionary thing that makes a lot of people mad sometimes. The president also has the authority to basically do other crazy discretionary things like carry out diplomacy, right? He's our chief diplomat. He conducts foreign affairs, and because we all live in 2024, we know the wild swings that happen from administration to administration in the way those foreign affairs, that diplomacy gets conducted. Again, a very discretionary, very broad power. Think about his power as commander-in-chief of the military, same thing. Incredibly discretionary power, incredibly broad power. So all of these things, especially these two factors, the power is wielded by him alone, and the power is incredibly broad and incredibly discretionary. These two sort of unique things that belong to the president make him, in the words of the Fitzgerald Court, an easily identifiable target for litigation. So people would want to sue him constantly because they were angry about the way that a president exercised his constitutional authority. So it's the very nature of the presidency, in other words, that inherently creates this prospect of never-ending lawsuits against a president based on the manner in which he exercises his constitutional authority. And if we allowed all of these lawsuits to go forward, it would be basically a boon for his opponents. You would give any president's political opponents this incredibly powerful weapon to use against the president to undermine his presidency, to make sure he was subject to a barrage of constant lawsuits that would distract him essentially from being able to do what he needed to do on behalf of the country. Now, we call this today lawfare, right? It's a word that I don't know about you, but I didn't hear about. I didn't even know it existed until probably about 5 years ago. But now everybody knows what lawfare is. And even though the Fitzgerald Court didn't use the word lawfare, this is what they're talking about. They're concerned about constant litigation against a president for exercising his constitutional authority that's dangerous to the presidency qua presidency, the presidency itself. Because it would not only sort of undermine and handicap the presidency, but it would be damaging, if you will, to the American people, right? Because we elect a president with the expectation that the president is going to sort of fearlessly and fulsomely carry out his Article II constitutional authority on our behalf. Now, like I said, Fitzgerald has been around for 25 years, and nothing's really happened. Like, the sky has not fallen. And in fact, 25 years ago, I was in law school. And this was something that nobody thought was a big deal, that the president would have immunity from civil litigation based on his official acts. But somehow there's something about Trump and the Supreme Court deciding this summer to extend that immunity to criminal prosecutions that's caused a lot of people to kind of go cuckoo for Cocoa Puffs. All right, but the whole idea here is that if Fitzgerald holds that there's separation of powers reasons for immunity for official acts against civil suits, then surely there must be similar immunity, the same immunity for official acts that trigger criminal prosecutions. Because if civil suits are too distracting of the presidency, if they sap the presidency of vigor, then surely criminal prosecutions must be even more destructive of separation of powers and the presidency. So that's all the Supreme Court did this summer, simply extended that immunity that it already recognized in Fitzgerald from civil cases to criminal cases. Now, so what we're left with at this point is a president who has this immunity from both civil and criminal liability if he is, in fact, doing something that is an act the Constitution allows him to do. But the important thing to realize is that when a president goes beyond this, when a president acts beyond his constitutional authority, he remains fully legally accountable, right? Think about it this way. The president can and does get sued all the time, right? We know that. I'm a lawyer. I've been involved in some of these cases against the president, all right? Presidents get sued all the time. So what happens in these lawsuits? Well, these lawsuits are brought because the allegation is that the president has exceeded his constitutional authority. And when that happens, if the judiciary agrees that the president has exceeded his authority, they're more than willing and able to rule against the president and hold him within his constitutional bounds. Again, plenty of examples, but I'll just give you a few recent ones. President Biden, on at least 3 occasions I can think of, has been held to have acted beyond his constitutional authority. The first big one was when he imposed a vaccine mandate, a COVID vaccine mandate for non-healthcare workers. Supreme Court struck that down. He imposed a unilateral moratorium on eviction for landlords during COVID. That got struck down by the Supreme Court. And the last one that I can think of is he tried to unilaterally forgive billions and billions of dollars in student loans, and that got struck down. So, you know, it's clear that we're not talking about a president doing something that's a frolic and detour. If he's going on a frolic and detour and it's not constitutional, he's fully accountable through appropriate judicial actions. The other thing to realize, too, is that Congress can hold the president accountable, too, if he acts beyond his constitutional authority. The normal way that Congress does that is through impeachment. Now, the other thing I want you to realize is that now that we kind of know what the immunity is and what it is not, is that it's nothing particularly earth-shattering because the other 2 branches of government get the same immunity. Right? So in 1971, Gravel versus United States, the court held that members of Congress have absolute immunity for official legislative acts, right? And the primary reason why the members of Congress got that was because of the speech and debate clause of Article 1, Section 6. But even in the absence of express constitutional language like that in the speech and debate clause, in 1871, the Supreme Court in a case called Bradley versus Fisher held that separation of powers requires federal judges to have official acts immunity for official judicial acts. Same thing, even federal prosecutors enjoy official acts immunity. The court decided that in 1927 in a case called Uselli versus Goff. And they reasoned that prosecutorial independence is necessary to the proper functioning of the judicial branch. So that's a separation of powers-based decision as well. So all of these decisions basically are saying that any 3 of the branches, any officers of the 3 branches who transgress their constitutional authority can be held accountable, but when they act within their constitutional authority, they are not to be subjected to lawfare. So if you are someone who doesn't like the way, for example, a president or a Congress behaves when exercising their lawful constitutional authority, basically you're trying to litigate against these individuals, not because they did something they weren't allowed to do. They are allowed to do it. The Constitution allows them to do it. But because you don't like the way, the manner in which they exercise their constitutional authority. And when that happens and you don't like the way they exercise their constitutional authority, the remedies are political. They're not legal. So for example, if Congress passes a law that you don't like, but it's well within their authority, as we know, to pass laws, at least if it falls within the enumerations of Article 1, Section 8, then what's the remedy? Well, you vote the bastards out, right? They don't get reelected. Same thing with federal judges. When federal judges have jurisdiction in a case and they're presiding over a case, but if they engage in sort of unseemly or unethical behavior, right? They're drunk on the bench, and that does happen. Then the remedy is a political one. They can be impeached, right? Because impeachment is inherently a political thing. And presidents should be treated no differently, and they're not now that the Supreme Court has extended this immunity to criminal cases as well as civil. And the final thing I'll say is that a lot of people continually say that, well, immunity places the president above the law. He's above the law. He's a king, right? No, absolutely not. That's absolutely inflammatory rhetoric that has nothing to do with reality. Because the whole point here is that this is separation of powers. This is the Constitution itself upon which immunity is based. It is the very architecture of the Constitution. The idea of not harassing someone who's exercising authority that the Constitution gives them just because you don't like the way in which they've exercised that authority. And because that is the basis for immunity, it's not placing the president above the law. It is an articulation of the law, of the highest law, of constitutional law. And Constitution is the supreme law of the land under the Supremacy Clause. If we allowed a regular statute to trump constitutional law, that'd be turning the Supremacy Clause on its head. And I don't think anybody thinks that that would be a good idea. But I'm sure you'll have lots of questions, so I'm going to stop there because I just got a 1-minute warning. So thank you very much.
Thank you. Yeah, Glenn, just a slightly different protocol. Professor Foley has had our timekeeper in the front row flash 5-minute, 2-minute, and 1-minute and 30-second cards. You won't be able to see that. And so I'm going to shout 5 minutes at you when the time comes, and I'll give you an extra. It could break your stride. So I think Professor Foley won't mind if we give you an extra 44 seconds to do your presentation, because that will slow you down. You're going to hear me shout 5 minutes at you after 12.5 minutes. 17.5 minutes. Take it away, Glenn, taking the negative on the resolution. Go ahead.
Thank you, Gene. Good evening, everybody. And by the way, Gene, just to let you know, I actually do have a timer that I can see visibly on the screen. So if you feel free to yell at me 5 minutes if you want, but I don't actually think it'll be necessary because I have the same timer that Professor Foley had, so I can see my time.
We're not sure we can trust you.
Let me begin by saying, let me begin by saying thank you so much to the Soho Forum, to the Smith Foundation, to the Reason Foundation. It's great to see you again, Gene. I wish I were there in person. Just to leave this not mysterious, I injured my knee playing tennis last week, and I actually need surgery on it. It's very hard to get around. My kids, if they were here, will tell you that it's a byproduct of my getting old. I kind of insist it's a byproduct of my athletic prowess. Maybe they and I can have a debate about that the next time the Soho Forum wants a debate. But in any event, I'm glad that we were able to make this work because I'm really looking forward to this debate. I think it's an incredibly important one. And I want to begin by doing something I'm unlikely to do for the next 90 minutes or so, which is I want to actually agree with something that Professor Foley said, and not just agree in passing, but agree quite wholeheartedly, which is she began, as I am, by saying that there was really nothing so shocking about the ruling in Trump versus the United States a few months ago, even though, as she said, it created this huge outcry in our political class. I agree that if you look at how the United States has developed judicially and politically over the last 35 years, really going back to, say, the pardon of President Nixon, it has unfortunately become part of our norms that presidents, in fact, are above the law, meaning that if they break the law, if they violate the criminal law while in office, they are not, in fact, treated like you are or anybody else is, because they are shielded, or as the court called it, immune from prosecution, whereas nobody else in the citizenry is. Now, Professor Foley said, that gets referred to as placing presidents above the law, which was the principal concern of the founders not to do, that we should not replicate the abuses of the British monarch and any other kind of monarch by putting people in one position vis-a-vis the law or other people in other positions vis-a-vis the law. We're all equal before the law. That was a foundational principle of the United States. But she said, well, you're not doing that because the law is that presidents are immune. Well, if that's true, the British king wasn't above the law either, because the British monarchy held, the prevailing law held, that kings cannot be held accountable under the law. So I think that's very semantic. Of course, it's the case that if you grant immunity, even for criminal violations, clear-cut criminal violations, and say that any citizen that breaks this one law here, everyone in the United States will be criminally prosecuted, but this one person, the president, is above that. He cannot be held criminally accountable. Then we are recreating the exact abuses of the British monarchy that the founders fought so hard to liberate themselves in a very dangerous and bloody war. And obviously the first thing on their mind was how to avoid in replicating that, when we create a centralized federal government to which all states and all citizens were bound, they were obsessed with that question. In the Federalist Papers, the Constitutional Convention, and every one of them, they all had different views about the extent of executive power. Alexander Hamilton believed we should have a very robust executive. James Madison, Thomas Jefferson were more worried that a robust executive would end up being more like the king. But all of them agreed and said explicitly that, of course, if presidents break the criminal law, impeachment's not enough. Impeachment in the Constitution is one way we get them out of office, but the Constitution itself and every founder who participated in the founding of our country emphasized that it's vital that presidents be held in the same status under the law as everybody else. Now, I want to just read quickly the resolution that we're actually technically debating and eventually voting on, because the question is not, did Trump versus United States 3 months ago rule correctly, given precedents over the last 15, 20, 25 years that have created this very modern day immunity for presidents in other contexts, never in the criminal law before, but in other contexts. But that's not the question we're asking. Was Trump versus United States rightly decided? The question we're asking is, quote, presidential immunity for official acts is a key factor in the proper functioning of the U.S. government's executive branch, the proper functioning. So it's not, did the court get it right legally in what was really its 5-3-1 decision because Justice Coney Barrett dissented in a lot of parts of the majority opinion. So that's not the issue. The issue is, when we have a federal government and a republic, do we actually advance the proper functioning of the executive branch by holding that nothing a president does while in office relating to their official acts, even if it's a blatant crime, can ever be criminally prosecuted? And I would suggest not only is it not advancing the proper function of the government and the executive branch, it's actually destroying it. It's making it impossible to have a political system that inspires trust or that deserves credibility, because of course we're placing our political officials above the law. Now, let me just make a couple points, because of course it is the case that there were founders who wanted a strong executive branch. And as I said, Alexander Hamilton was probably among the founders, the most vocal advocate of that. Yet even he, in the Federalist Papers and Federalist 69, understood that although it's important to have a strong executive, it's at least as important, if not more so, to avoid recreating the king. And to do that, he said the following, quote, the president of the United States would be liable to be impeached, tried, and upon conviction afterwards, liable to prosecution and punishment in the ordinary course of law. That was one of the ways Alexander Hamilton was emphasizing that although we're going to have a strong executive with a lot of powers shared by Congress and the judiciary, if he breaks the law, he's not like the British king, because after he gets out of the office, or if he's impeached, that's not the only remedy for violating the criminal law. It's also, as he put it, being prosecuted and punished in the ordinary course of law, talking about the president. I think it's also really important to note that the founders did actually debate the question of immunity, and Professor Foley actually referenced this. They knew how to give immunity if they thought that a particular part of the government should have it. And there's only one time they did it. And that was in Section 1, Article 6, where, as Professor Foley noted, the Constitution states explicitly that members of Congress have immunity for anything they say or do on the floor of the Congress in the speech and debate clause. So they knew what immunity was. They debated whether presidents should be immunized under the criminal law. They did not put that in the Constitution because none of them believed it. They did believe it. There should be immunity in this one limited sense, because otherwise you couldn't have a functioning Congress that was liable to be treated as criminal dissidents for things that they said on the floor of the Congress. So you could even have, for example, members of Congress go and read the Pentagon Papers, which Daniel Ellsberg tried to get them to do on the grounds that you're immunized. And that's because the Constitution gives immunity for that. It does not give immunity anywhere else. This is something we've invented out of whole cloth over the last several decades in something that has been very disturbing. Now, just to emphasize how central this preoccupation was until very recently with making sure presidents aren't like kings, I just want to say what I think is the most important precedent on the questions of the extent of presidential power and executive power, which predates most of what Professor Foley referred to. This is from the case of Youngstown Sheet in 1952. That was under the Truman administration. It's a very interesting case because there was the Korean War that was underway and that the United States was prosecuting. Obviously, we had declared it to be in our great national interest to win the war in Korea. And steel workers at major steel companies were threatening to strike, which would have had the effect of impeding our steel production and therefore impeded the war effort that President Truman under the Constitution was prosecuting. So you could argue there he was at his highest level of power. He's the commander-in-chief of a war authorized by Congress, and he's, in his judgment, acting to prevent the impediment of steel production because he wanted to seize the steel companies and put them under the control of the government for as long as the war lasted. And the Supreme Court said, no, you cannot do that. Even though you're the commander-in-chief, even though you might have immense national security powers under the Constitution, your powers are not unlimited. We don't have unlimited powers in this country. All powers are shared by Congress and the court. And what Justice Jackson said in his concurring opinion, which I think everybody would agree has become the most influential part of that opinion, he said, quote, the example of such unlimited executive power that must have impressed the forefathers was the prerogative exercised by George III. And the description of its evils in the Declaration of Independence leads me to doubt that they were creating their new executive in his image. And that's exactly right. If you were to give full immunity of the kind Professor Foley wants to presidents, where she's really saying, as long as you're exercising whatever power under the presidency that you have, you can commit any crimes you want, no matter how blatant, no matter how egregious, no matter how ill-motivated, and you can never be prosecuted under any circumstances as long as you say it was relating to or in the exercise of your power. That would, of course, mean we're placing presidents above the law. Just to give you a really important example, because I think this is crucial to note that there are two different kinds of presidential powers. One is power vested in the presidency that is also vested in the other branches, particularly the Congress. So Professor Foley talked about what she called the virtually discretionary or wide power in foreign affairs. But as that Steele case noted that I just read, even there, the president's powers are limited. The Congress has the power to declare war. The Congress is responsible under Article 1 for raising the Army and the Navy. And so there's a lot of shared powers. Most powers are shared. There are only a couple of powers that are really reserved exclusively for the presidency, one of which is the pardon power. So under Professor Foley's vision of how the United States should work, you can imagine a case where a president says, I'm issuing a pardon, and the reason I'm doing so, let's say they're doing it in the lame duck, like right now, and the reason I'm doing so is because I was bribed to do so. I was paid $1 million if I were to give this pardon, and I'm giving this pardon for $1 million. I was bribed. It's under the criminal statute. But because the pardon is one of my core presidential powers under the Constitution, in fact, it's one of the few that isn't shared with the Congress, it means that I'm free to exercise that power however I want, even if it's flagrantly criminal, and I will be immunized from prosecution afterward as a result of this immunity that the court 3 months ago and that Professor Foley is advocating. And if you look at everything the founders have said, I think you will find that it is a radical deviation from what they had in mind, and not just what they had in mind, but what they actually set out to create and to prohibit in what should still be our governing document, which is the Constitution and the Federalist Papers and debates around it that illuminate what it was intended to mean. Now, I say this is a very recent development, this idea that presidents should be immune even if they commit crimes, because it's actually the thing that motivated me to start leaving my profession as a practicing lawyer and becoming a journalist and wanting to have a bigger role in the public debate we were having about our politics and our law, because it was after 9/11 when I began to see that these very radical theories of executive power started to be promulgated under the Bush and Cheney administration. Dick Cheney was a long-time advocate of the kind of unlimited executive power that Professor Foley seems to support, at least to some extent. So much so that even going back to the Reagan years, when there was the scandal about Iran-Contra, where the Congress had prohibited the executive, the president, from using any funds of the United States to give to the Nicaraguan Contras to help overthrow the government. The executive branch ignored that and violated it and went behind Congress's back. They secretly sold missiles to Iran, got that money, and transferred it to Nicaragua in violation of congressional law. And the theories of why that was permissible that came from a then fringe group advocating presidential immunity was that, look, presidents are free to do whatever they want in foreign affairs, and not even Congress can limit them. It doesn't matter that Congress passed a law called the Bolin Amendment, banning us from giving money to the Contras. That's for the president and he alone to decide. And that was a very radical fringe view of what the American presidency was. And unfortunately, it really took hold out of exploiting the fears of 9/11. It's what I began writing about when the Bush Justice Department started doing things like torturing people, putting people in prison with no due process, with no opportunity to even have a single day in court of habeas corpus to contest their guilt, kidnapping people off the streets of Europe and sending them to Egypt and Syria to be tortured and interrogated, putting people in CIA black sites beyond the reach of human rights organizations and international conventions. And I think most offensively of all, spying on the telephone calls and other communications of American citizens without the warrants required by law. So Professor Foley said, oh, well, we've had this for 30 years now under Nixon, and the sky hasn't fallen. I think it's fallen. I think the Iran-Contra scandal was an incredibly egregious criminal violation that nobody was ever held accountable for, in part because of this idea of presidential immunity, but also because George Bush 41 pardoned everybody on his way out and therefore prevented any investigation from coming to his door. He was also obstructing justice, but the idea was presidents can't be held criminally accountable as long as they're exercising powers of the presidency, like the pardon. And that's why I use the more even extreme example that even if they were to admit they were bribed for it, under this immunity clause, they couldn't be. And I think the War on Terror one is a great example. And this really did come from Richard Nixon. In 1977, after his presidency, Richard Nixon sat down with for a very famous interview with David Frost, the great television interviewer, the English television interviewer. And the thing people remember most about what President Nixon said, because it was so shocking when compared to people's understanding of what our country was supposed to be, was when he basically stood up and said what the court said and what Professor Foley is saying, which is, I am the law as the president. I can't be prosecuted for the law. I am the law. And this is what he said. David Frost asked the former President Nixon, so what in a sense you're saying is that there are situations where the president can decide that it's in the best interest of the nation or something and do something illegal. And President Nixon responded, well, when the president does it, that means it is not illegal. And then David Frost said, by definition, and Nixon said, exactly. If the president, for example, approves something because of the national security, or in the case because of a threat to internal peace or order of significant magnitude, then the president's decision in that interest is one that enables those who carry it out without violating a law. Now, a lot of the controversy from the War on Terror came because Dick Cheney and Paul Wolfowitz were able to find people in the bowels of the Justice Department, very fringe radical lawyers like John Yoo, to write memos saying torturing people is legal, putting them in cages underground away from the human rights organizations is legal, so is kidnapping people off the streets is illegal. And that became very controversial. The Bush administration said, we're acting legally. We have these Justice Department memos. But if you believe Professor Foley's vision of America, why were those even necessary? George Bush and Dick Cheney could have just tortured away, could have spied on Americans with no warrants as they did, done any of that with no memos at all saying it's legal, and afterwards said, we can't be prosecuted. We're the president. We're above the law, the criminal law. Or in the words of Professor Foley, not above the criminal law, not above the law because the law says that the president is above the law, and therefore that immunity is part of the law. So I think in theory, this is not only very dangerous and contrary to our founding, I think we've seen repeated instances over the past several decades of how dangerous it can be for presidents to first believe they're culturally or through political norms immunized for punishment when breaking the law and committing crimes, and even more so when we implement that tactically. And whatever else that is, if you look at the resolution we're debating, that is not the advancement of the proper functioning of the executive branch.
Thank you, Glenn. Yeah, okay. Yes, Glenn went 30 seconds over, so you get an extra 30 seconds for your rebuttal. Thank you, Glenn. 7.5 minutes of rebuttal from you. You can take the podium if you'd like. Yeah.
Oh. So little time to rebut everything. I'll try to start in order. First, the comment about the founders didn't want to place the president above the law. Yeah, there was a saying for that. The saying was, the king can do no wrong. Okay? But what the founders did to reject that was they rejected the whole concept of the British monarchy, which was set forth most eloquently, probably, by Thomas Hobbes in his famous book, The Leviathan. And his thesis, of course, in The Leviathan, as the name suggests, is that the British monarch was a Leviathan. It was omnipotent. It had no limitation to its powers. So the great genius of the American presidency as set forth in the Constitution is that the president is only given, just like Congress is only given limited and enumerated powers only. And even though those powers, as I have discussed previously, are broad, like the commander-in-chief power, the power to faithfully execute the law, and they are inherently discretionary, they're not unlimited, okay? So this is not making the American president like the British monarch. The structure of the Constitution and limited enumerated powers makes the presidency extremely difficult, different and circumscribed from the British monarch. The second thing is that I think Glenn mentioned Hamilton's number 69, which basically is the basis for what's called the impeachment judgment clause. And the impeachment judgment clause says that judgments in cases of impeachment shall not extend any further than from removal in office. And then it does say that, nevertheless, the person who is successfully impeached is subject to indictment and trial according to law. Okay, and so the question is, what does that mean according to law? The impeachment judgment clause is a provision that basically just says, this is how far impeachment can go. It can go to your removal from office and your disqualification from future office, but it says absolutely nothing about immunity. So the Supreme Court had to figure out if the president had any immunity whatsoever consistent with that clause. And by the way, one thing I will say is you take the impeachment judgment clause and you take the impeachment removal clause, two different clauses in the Constitution that speak about the impeachment. And the latter one talks about how the president and the vice president and other civil officers of the United States, if they are successfully impeached, can be removed, but not always. They can only be removed for treason, bribery, and other high crimes and misdemeanors. And you put those two things together, neither one of them speaks of immunity, but they clearly speak of something envisioning a president or the vice president or other civil officers being pursued for things like treason, bribery, or other high crimes and misdemeanors. And you say to yourself, well, see, there you go. The president can be subject to criminal prosecution. Well, no, not necessarily, because first of all, treason, bribery, and other high crimes and misdemeanors, number one, are crimes not only under federal law, but state law too. And all of these immunity cases we're talking about, both Fitzgerald and Trump, are dealing with horizontal separation of powers. In other words, federal officers' immunity from federal judicial proceedings. They don't talk about state proceedings. So, for example, whether former President Trump, let's just say he acted officially when he paid Michael Cohen hush money on Stormy Daniels, which I don't think he did. I don't think you could spin that as official act, no matter how broad official acts is. But let's just say, for purposes of argument, that it is an official act, that the president under Article 2 has the power to pay hush money to a former porn star. All right, if that's the case, then he would be immune under federal jurisdiction from federal court prosecutions. But it doesn't say anything about state prosecutions, which is how he's being prosecuted, of course, in New York. So that is actually an open question. Another thing I'll say is the proper functioning. Glenn talked about the proper functioning of the presidency. it is the basis of the whole idea of immunity is that proper functioning, to make sure that the presidency, qua presidency, when he is acting within his Article II authority, is not impeded from doing so, is not fearful of doing so because of sort of the threat or the prospect of lawsuits or criminal prosecution hanging over his head. Next thing he said is, well, there's no express statement in the Constitution that there's immunity. Well, yeah, but separation of powers is not expressly stated in the Constitution either. Right? But the Supreme Court has long had tons and tons and tons of separation of powers jurisprudence. Immunity is one of them. It's part of it. It's part of its separation of powers jurisprudence. So if you think everything has to be expressed in the Constitution in order for it to exist, that's not the way American constitutional law has ever worked. And if it hasn't worked in other areas, it shouldn't have to work in this particular instance either, if you can see a clear separation of powers rationale for the immunity. He then mentioned the Youngstown case, the steel seizure case. Well, the Supreme Court only held in Youngstown that President Truman couldn't seize domestic steel mills to aid the Korean War effort because the power of seizure belongs to Congress and Congress alone. Congress alone has the ability to take property for public uses and to pay under the Fifth Amendment Takings Clause just compensation for that kind of taking. So Youngstown said absolutely nothing about immunity. And in fact, what the court did say is that the commander-in-chief authority, which I think Glenn tried to spin as having some basis for the Trump immunity, the commander-in-chief authority, the court said in Youngstown, is not a domestic authority. He does not have the power. He has no Article II authority, in other words, to seize domestic industry. That is not what commander-in-chief does. He doesn't seize domestic industry. So they did make that clear that that would not be an official act if he did that. And if he did do that, then he would not be entitled to immunity. And he wasn't entitled to immunity because he lost the case. And then Glenn talked about shared power between the president and Congress. Well, there are plenty of areas of shared power of the president and Congress. Foreign affairs is one of them. The president has really the sole power of conducting diplomacy under a clause called the Receive Ambassadors Clause. But a lot of the foreign affairs power is shared with Congress because of Congress's appropriation role and some other things that Congress does that probably aren't relevant here. But they do have some shared authority in the way that foreign affairs gets conducted. But what's interesting, and Glenn didn't mention, is the Supreme Court has another doctrine called the political question doctrine. It's called PQD when I teach it. The political question doctrine is a doctrine that was recognized by Chief Justice Marbury in 1803, Chief Justice John Marshall in a case called Marbury versus Madison in 1803. You probably heard that big case before. And it basically is a doctrine that says when the Constitution gives power X to the other two branches, the political branches, Congress or the president. When the Constitution textually and demonstrably gives power X to the other two branches, the judiciary will not adjudicate a dispute involving that power. That's the political question doctrine. It's based on separation of powers, and its rationale is exactly the same as the immunity cases. And I hope somebody asks, because I'm running out of time, about the bribery hypothetical of Justice Sotomayor and the pardon hypothetical of Sotomayor, because I do have some things to say about that, but I don't have time right now.
No. Thank you. 7.5 minutes of rebuttal. Take it away, Glenn.
Great. Yeah, definitely the last time we had a debate here, the audience questions served a great purpose in allowing us the time to delve into a lot of these things further. So I'm sure we will both have that. I did want to address a couple things. First of all, I want to just emphasize once again this fact that you can look up and down all over the Constitution or the Federalist Papers or the debates about the Constitutional Convention, and you will never find a single word in favor of the idea that presidents are immune under the criminal law. Not a whisper, not a word. It's completely invented. And the reason why it's so important, aside from the fact that you can't just make up protections for the president out of the blue, is because, again, they knew how to make people immune when they wanted to. That's why there's that clause that says that members of Congress are immune for this one specific act, the speech and debate clause. So if they wanted to make presidents immune, there would be a clause like that in Article 2 that says presidents are immune when exercising these kinds of powers. It's not there. And the reason it's not there is not because they forgot about it. It's because, as I read in the first time I spoke, even the most vigorous advocates of the idea that you have to have a strong, robust executive, unworried about little rules and being, Alexander Hamilton specifically said that you also need, on the other side, the idea that the president knows that he's subject to punishment. Professor Foley said in response, well, there are other things not in the Constitution, like the separation of powers, that's not explicitly there yet. Courts have recognized it. The reason courts recognize the separation of powers is because it's all over the Federalist Papers. It's all over the Constitutional Convention. The entire Constitution is based on this idea. You can just look at a couple of passages, key passages from James Madison Federalist 48, in which he said there's no way to have a healthy government, quote, unless these departments, the judiciary, the executive, and the legislature be so far connected and blended as to give each a constitutional control over the other. The degree of separation which the maximum requires are essential to a free government. And then in 51, he said, the best and most important thing we can do is, quote, contriving the interior structure of the government so that its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places. The Supreme Court didn't just invent separation of powers out of whole cloth. It's all over the Federalist Papers. And the only thing in the Federalist Papers, let alone in the Constitution, about what we're here to debate and what we're going to vote on, what we have voted on, what we're going to vote on again, which is the idea of whether or not we should have presidential immunity, not only is that nowhere in any of these documents, they said it's a very modern idea that has done a lot of damage. What it actually is negated and contravened by everything in the Federalist Papers when they actually did address the question of presidential immunity, because like congressional immunity, which they addressed, they also knew they had to address that, and they addressed it by saying it would be horrifying to have the idea that presidents commit crimes in connection with the powers of their office and then leave office and be immunized. And one of the things I omitted to say is that there is a constitutional provision on exactly this question. I think Professor Foley said one of the ideas in the beginning was, well, if you don't like what they do in office, you're offended, you're angry, you can vote the bastards out, you can impeach them. That's all true. Those are our remedies. But for the question of committing egregious crimes while in office as president, that is insufficient. And the Constitution itself says so. So in the impeachment clause, which is Article 1, Section 3, that gives Senate the various powers, it says that, and this is impeachment, judgment in cases of impeachment shall not extend further than to remove from office, but the party convicted, meaning the president, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, Professor Foley said, well, what does that mean according to law? And this is where I think we get into the real essence of what we're talking about here, because the example that I tried to provide, which was on purpose the most extreme example, a president admitting, I gave this pardon because someone gave me $1 million and bribed me. Even put it on video. Hey, I'll pay you $1 million if you pardon me. Give me the money, here's where to wire it to, here's your pardon. According to Professor Foley's vision of America, that president cannot be prosecuted because what they did was in the exercise of their duty. There's no question a presidential pardon is in the duty, is a power the Constitution assigns to the president. It's one of the very few powers he doesn't share with the Congress or the courts. So it's the strongest case for letting the president be unrestrained. But do you think that would be a beneficial way to have the executive branch function, that you could commit a crime that egregious and then be immunized afterwards? Professor Foley tried to say, oh, everybody else in the government gets this immunity. I think we all know that's untrue. If, for example, a member of Congress, as it happened many times, gets caught, say, accepting a bribe for doing things that is completely within their power as a member of Congress, like introducing a law or pushing a law or calling a regulator, but they're doing it for improper purposes. If they weren't doing it for bribery or other improper purposes, it would be perfectly permissible. But if they commit a crime by doing it, of course they can and have been prosecuted. Members of Congress have been prosecuted for things like bribery, for taking money to exercise their constitutional powers as a member of Congress in a certain way. Of course, that's also true for judges. There are judges sitting in prison right now because they did things like ruled on motions or issued verdicts, all things that a judge is not just able to do, but must do to exercise their office. But if they commit a crime when doing it by accepting a bribe, of course they're going to go to jail. And of course they have to go to jail. Imagine how horrible and dysfunctional our government would be if anybody who wields government power knew that they could do so in the most criminal way possible and then get immunity afterwards. And we've seen the devastating impact. Once President Nixon was immunized and the country said, maybe we shouldn't put presidents into criminal courts. Maybe their top advisors, the attorney general, their cabinet, but not the president. We don't want them in criminal courts. And then ever since, we've gotten increasingly brazen criminal activity, as the example that I highlighted suggested. The last thing Prof. Foley said, honestly, confounded me a little bit. She said, well, maybe they could still be prosecuted by the state, even if there's really something that egregious. Well, if immunity is so important to let presidents be presidents, how does letting them be prosecuted by the states achieve anything? They would have the same hesitation and everything else. I don't really think it's a question. Once the Supreme Court ruled in favor of President Trump, the New York case froze because the judge had to figure out, and the prosecutors did, what effect it had on that case. It's either immunity from the prosecution or no immunity at all. And look, I think there are ways to say you want to give the president the way to act without being afraid they're going to be sued. We want doctors to be able to operate without fear of getting sued. They have special license, but if they go too far, if it's too egregious, they can be prosecuted or sued. There's no reason president should be any different. And in the Constitution, the Federalist Papers, and the design of our country, they're not.
Thank you, Glenn. We now go to the Q&A portion. I want to start with moderator's prerogative and just ask one question of you both. And since it's an issue that you brought up, Glenn, I want to have you answer the question first. You specifically cited in practice what you felt to be a criminal action on the part of the George W. Bush Cheney administration. Could you elaborate on anything else since Bush Cheney? Let's just limit it to the presidents since them. How serious do you think this is? And are there any of those presidents since Bush Cheney that you would not indict for criminal activity?
I think that, well, first of all, President Obama, despite running on a platform of uprooting a lot of those policies, ended up not just defending them, but strengthening them in a lot of ways. But I think the original sin was creating these memos to give a cover of legality to what they believed without them would likely be crimes. And the worst of those was probably the spying on Americans without the warrants required by law, because you had a specific congressional act. You don't have to resort to international law called FISA that was negotiated by the executive and the legislature after the abuses of the Warren Commission in the 1970s, where they said you need some limits on presidential spying. You have to go to the FISA court. It's not very onerous. There's no, only the government goes. And the Bush and Cheney administration decided that it was going to just ignore that and argue later that it had the right to ignore congressional law because the Congress couldn't restrain what they were going to do. That, to me, is criminal behavior, to deliberately and purposely ignore a law, like was done in the Iran-Contra scandal. And the concern, of course, is that if you give immunity, as we've been doing, you're signaling to presidents in the future that they could break any law as well, and there's no reason why they should be fearful of doing so. And that's why I think it's not just unconstitutional, but quite damaging to send that signal.
Professor Foley, could you address the same question? Glenn has, first of all, obviously alleged that the Cheney-Bush administration committed a crime. He cited another crime committed by presidents. Do you regard these, first of all, do you agree with him that these are criminal acts, and would you impose criminal charges against them for these specific criminal acts that Glenn cites?
Well, I mean, I'm going to be a lawyer here because that's what I am. And ask for what? I mean, Glenn says, for example, that Bush and Cheney committed a crime. What crime did they commit?
Go ahead, Glenn.
Well, I think the two I named were torturing people, which is violation of domestic law and international law, and then spying on Americans without the warrants required by the FISA law.
Okay, so first of all, the torturing occurred where?
Okay,
It
go ahead.
occurred in a place the Supreme Court said the United States had sovereignty over, and therefore the Constitution applied, which was Guantanamo, as well as Bagram, places where the U.S. acted as sovereign.
Okay, well, I'm asking for reasons, right? So Gitmo, it's an open question, for example, as to whether or not the prohibitions on torture in international conventions is binding on the United States, absent implementing legislation by Congress. I mean, you're a lawyer, you know the whole idea of self-executing versus non-self-executing treaties and conventions. So that's an open question. So you're making a statement that it is against the law when I'm saying as a lawyer, you don't know that it's against the law because there's been no conclusion that it is. And you may not like it, I get it, I'm with you. And for example, I mean, you keep saying, oh, Foley and Professor Foley's vision of the world, Professor Foley's vision of the world, as though I'm some person who wants a Leviathan-like president. I absolutely do not. I believe in the unitary executive only because the Constitution creates a unitary executive, so it's not me that loves this. I think the president ought to be held to stay within his constitutional bounds, just like the Congress ought to be held within its constitutional bounds. So I want to make that clear. The other thing, too, is you mentioned unlawful searches and seizures. But I'm sure you know that presidents can be held accountable for unlawful searches and seizures. I mean, there is a thing called a Bivens action, which is the functional equivalent of a 1983 action against state officials, except you bring it against federal officials. And you can bring a Bivens action by definition for constitutional violations by any federal officer. Now, proof is difficult. I get that. There are evidentiary issues about whether you can ascribe certain things to the president qua president as opposed to his underlings. But as you know, there have been plenty of suits brought against, for example, Dick Cheney and the director of the FBI and the head of the Federal Bureau of Prisons for committing various constitutional violations in post 9/11. And some of those have gotten litigated and some of them have not, depending on standing issues. But to suggest that the president is not subject to the Fourth Amendment, which is an external restraint on Article 2, is just wrong.
Okay, thank you. Now we're gonna keep it flexible. First, Glenn, if you want to ask Professor Foley a question, you can do so now or do so at any time during the Q&A. Professor Foley, if you'd like to ask Glenn a question, you can do so now, or you can step in during the Q&A from the audience. Do you want to waive the privilege for the moment, either of you, or do you want to ask each other a question? Glenn?
I have one quick question. I think it'll be a quick question, if you don't mind. Just on the hypothetical that I offered, which I deliberately made the most extreme as I possibly could, which is the idea that a president admits that he gave a pardon because he got $1 million bribe. It's on video that it happened. I presume you would say he's immune from prosecution because the pardon power is clearly an exercise of his constitutional power as president. But I just want to clarify whether that is your view.
Well, I'm glad you asked, Glenn. People don't like it. I'm a law professor. My answer is depends. Okay? I mean, look, if you go to a lawyer and you ask him questions, you give him a lot of facts, probably your lawyer's going to look at you and say, well, maybe, tell me more, right? So, for example, bribes. The problem with in exchange for pardon, the pardon power of the president under Article 2 appears textually to be plenary, right? There are no apparent textual limitations on the scope of the pardon power. And so, other than the fact that it has to be a pardon for a federal offense, he can't pardon state offenses, so the text does make that clear. And so one of the problems we have with the pardon power is that when somebody grants a pardon to, let's say, Bob, it's very hard to bring a case or controversy, a justiciable case under Article 3 of the Constitution because of the standing doctrine. It's this doctrine that the court has derived from these words, cases, and controversies under Article 3. And what I mean by that is you can't just sue any old president or any executive officer or any officer of the government because you don't like what they've done. You have to have an injury in fact that was caused by that person and is redressable. And so when a president pardons Bob, none of us are going to have standing to challenge that. It's not going to be a justiciable case or controversy. So we don't have a lot of case law on the scope of the pardon power because of the lack of standing of ordinary people to bring the lawsuit. And that has nothing to do with immunity. It's just a standing doctrine that applies across the board. So I don't know what the answer to that would be. Are there any limitations that the court would imply into the pardon power that are not apparent from its text? I think it's possible. So for example, President Nixon, when he got pardoned by Ford, that was a prophylactic pardon and it was a blanket pardon. It was prophylactic in the sense that, it may have been for things that President Nixon had previously done, and it may have been for some things he had done afterwards. But more importantly, it was a blanket pardon in the sense that if he did anything with relationship to Watergate, that pardon covered it, right? And we just saw that. We saw it with President Biden and his pardon of his son. It was also sort of a blanket pardon. And whether those kinds of blanket pardons are permissible, I just don't think, as a lawyer, if I'm being honest with everybody in the room, I don't know if those are permissible under Article 2 or not, because I've never seen a case litigated. I've never seen someone with standing being able to bring the case. In fact, if you wanted to be able to bring a case like that, what you would have to do, either with Hunter Biden or Nixon, is you would have to, after the pardon, you'd have to have some prosecutor, either a federal prosecutor or a state prosecutor, be so bold as to go ahead and bring a prosecution anyway against that person. And then that person who got the pardon would have to raise the pardon as a defense to the criminal prosecution, and then we could figure out in that case or controversy whether that blanket pardon was constitutional or not. So I just don't know. I hope not, right? I do hope, and let me give you the hope. There was a case called McDonnell a few years ago involving the Virginia governor, I don't know if you guys remember him, who got accused of taking bribes. Okay, so it's a bribery case under the federal bribery statute. It went all the way to the Supreme Court, and the Supreme Court had to construe the federal bribery statute. And it said that taking a bribe in relation to, if the quid pro quo is in relation to using your official authority, your official act, to try to convince a third party to do something, I know it's complicated, is not bribery. In other words, what the court was doing was narrowly construing the federal bribery statute to avoid separation of powers problems. And that makes me think there could be some hope that this hypothetical and a pardon in exchange for a bribe might not be within Article 2.
Okay. Do you want to, you can exercise that prerogative later to ask Glenn a question. Do you want to waive it at the moment or ask him a question?
No, I really want to get to the audience.
Sure, of course, yes.
You guys all showed up.
Okay, please ask your question, ask the question, and you don't need to identify yourself.
How you doing? So this is a question for both of you guys. Do you think that a president should be held criminally liable or personally criminally liable if they are using their official capacity legally, such as to, let's say, put down a riot? They send the National Guard in to put down a riot. The National Guard kills somebody as a result of that order, almost in a RICO-esque kind of way. Would that president then be held liable for the death of the person at the hands of the National Guard as it was their order?
All right.
That's an easy one.
Yeah.
Legally easy. The president has no authority as commander-in-chief to suppress a riot. Under the Posse Comitatus Act, he can't use the military for domestic law enforcement purposes. But more importantly, the National Guard, which is what your hypothetical presupposed, is controlled exclusively by governors, and in D.C., the D.C. mayor. So he would not be able to call out the National Guard. He would have to convince either the D.C. mayor or a state governor to call out that National Guard.
Do you want to comment, Glenn? Or do you want to? Any comment?
I'm okay. I'll probably work it into a subsequent answer.
Okay. Yeah. For those in the balcony, I apologize if we don't have a mic up there. We should, but I don't see a mic up there. So if you want to ask a question, then I guess come downstairs. Next question, please.
Scream real loud.
Yeah.
This is a question for both speakers. Are there comparable laws in other countries where prime ministers and presidents maintain a similar type of immunity, or is this unique to the United States, or is it uncommon?
Glenn, could you take that question?
I mean, I don't want to make such a broad statement as to say there are none, but I'm certainly not aware of any where presidents who commit crimes while in office in other, say, countries in the democratic world, here in Brazil, where I live, for example, which based its constitution very much on the US model, but also on European model, there have been presidents who, while in office, were first impeached and then criminally prosecuted for acts that they undertook while in the presidency, and it's considered to be a pretty good deterrent for future presidents to do the same. There may be one that Professor Foley knows about that I don't know about, but I would still say that's not a good model for us.
Comment from you, Professor Foley.
Yeah, so I do know that Spain does allow official acts immunity, just because I taught there a couple summers ago, or actually last summer. But I don't know, beyond that, I don't know. But one thing I would just clarify, though, is that, Glenn is presupposing that if someone gets impeached, they're getting impeached, for a crime. They don't always get impeached for crimes. President Clinton almost got impeached, not just for the perjury in the civil case, but for a lot of people were pushing impeachment for the sort of untoward personal behavior of having an affair with a White House intern. So presidents, they get impeached for various things. They can either get impeached for official acts, right? In which case, if it was an official act and it was something they had Article 2 authority to do, then they could be impeached, but they couldn't be criminally prosecuted because of immunity. But presidents also get impeached for things that are not their official acts. For example, the most blatant examples are presidents who exceed their constitutional authority. If you have a president who exceeds his constitutional authority, I would assume that a lot of us might get kind of angry and may want to impeach. Now, that hasn't happened in recent years, but I think it's not because we don't get mad when presidents exceed their constitutional authority. It's because it's difficult to get to the 2/3 supermajority threshold to convict in the Senate. So the way we usually handle the fact that presidents exceed their constitutional authority, and by the way, all presidents exceed their constitutional authority. They all try to push the envelope. They all try to do it. Is that we file lawsuits against them. I mean, I'm in the business of filing lawsuits. I have filed lawsuits against presidents and lots of executive branch officials for exceeding Article 2. And if they have exceeded their authority, they will be slapped down by the court. So again, I mean, Glenn makes immunity sound like it's this broad thing that the president can never be held accountable for a crime. He can be held accountable for all kinds of crimes, just not crimes that someone thinks are crimes because they think he shouldn't have the constitutional authority to do it. If he does have the constitutional authority to do X under the Constitution, then by definition, he's immune because he's following the Constitution. And there's no ordinary statute in the world that should be able to trump a constitutional ideal, a constitutional architectural provision. That's what immunity is all about. So immunity is not some blank check to the president.
So I did want to just interject there, actually, because there's a couple things said that I think are really important. First of all, I think we have to separate the question of a civil lawsuit that's brought to test the limits of presidential power versus what we're actually talking about, which is a clear-cut crime that Professor Foley believes the Supreme Court said ought to be fully immunized from criminal prosecution as long as the crime was committed in exercise of a presidential power. So when I was talking earlier about the warrantless eavesdropping, domestic eavesdropping on American citizens with no warrants, I wasn't talking about a violation of the Fourth Amendment. I was talking about a violation of the criminal law called FISA that was enacted in 1977 that said that the only way the federal government can spy on Americans is if they first go to the FISA court and get a warrant and convince the FISA judge that a warrant is appropriate, and anyone who spies on Americans without that warrant is committing a crime. The New York Times in 2005 revealed and won the Pulitzer for doing so that the Bush-Cheney administration had decided they weren't going to abide by that law, that they did not believe that law was a legitimate restraint on their power. And so they committed a series of acts on purpose that the law had said was a crime. And that's what I think is so important. The first speaker actually asked about quelling a riot. I don't necessarily support this, but presidents have taken the view that you can invoke the Insurrection Act and use the military, the National Guard to quell riots. That was done by George Bush 41 when the Rodney King riots broke out in Los Angeles. People were critical that President Trump didn't do it for the 2020 riots. But if somebody invokes the Insurrection Act and make a good faith attempt to say to the military, go and quell this riot, but the military, in the course of doing so, ends up killing somebody because they use excessive force, of course the president should be held criminally accountable. It was a policy gone wrong. If, however, the president says, I'm invoking the Insurrection Act, and then directs the military, go and murder all of my political opponents. If you see somebody with a sign that's critical of me or my party or my administration, I want you to gun them down. And then the military goes and does that. According to this theory that I'm hearing, and I tried to get an answer earlier on the egregious example of giving a pardon for a bribe, not whether that should be a civil case, but whether a prosecutor could prosecute the president for it. I didn't hear a yes. So I'm assuming that even egregious crimes and exercise of president's power, like I'm invoking the Insurrection Act, which is my power under the presidency, I'm using the military to quell a riot, and in the course of doing so, you order the military to go murder your political opponents. The theory that is being defended here would be, as long as it was done in connection with appropriate powers, even if the crime is super flagrant and super egregious, we just can't have presidents being prosecuted for acts in Congress. No one's talking about personal acts. Like, obviously, if the president rapes somebody, no one will say there's immunity because that has nothing to do with the exercise of presidential powers. The issue is, can they commit crimes to be prosecuted for in the exercise of presidential powers? And all these extreme examples I'm using would be ones where Professor Foley and the Supreme Court would have to say, no, even then they can't be.
Comment from you, Professor Foley.
Yeah, I mean, what I would say is you're presupposing, as you say, a clear-cut crime, quote unquote. But look at President Trump's prosecution in the January 6th Jack Smith, the special counsel prosecution in DDC. Were those clear-cut crimes? He charged President Trump with 4 violations of federal law. There were 2 obstruction-related counts under 1512C2, and then there was a violation of federal civil rights, and then there was an honest services fraud charge. And all of those statutes had to be bent out of contortion to make it apply to the things that in fact, none of them had ever been applied in any fact pattern, even anywhere close to what President Trump was charged with in that indictment. And in fact, 2 of the 4 counts, because they were obstruction counts, were struck down by the court in Fisher versus United States this summer too, which construed that obstruction statute very narrowly to probably not apply to Trump's acts. And we'll never get a final decision on that because, special counsel's indictment against him is being held in abeyance by Judge Chutkan on the assumption that when President Trump assumes office, he's going to fire special counsel Jack Smith. So we'll just never know. But given Fisher, I suspect those 2 counts were dead in the water. So we had 4 counts that were bizarre stretches of existing statutes. They were far from clear-cut crimes under those statutes. And what the Supreme Court in Trump said was, well, we're not really sure about whether or not some of the things Trump did were official acts or not official acts. And so the court was very actually restrained in that case and said, you know what, we're going to have to remand this case back to the trial court in D.C. to figure out whether or not President Trump was acting qua president, as the president when he did actions X, Y, and Z, or whether he was acting in the capacity of a private person, i.e. as a candidate for office. And so you always, under immunity, have to first ascertain whether what the president is doing is an official act or not. And just because somebody says it is doesn't make it so. So, for example, the SEAL Team 6 hypothetical, where the president guns down his political opponent when he's walking down Pennsylvania Avenue just because he doesn't like them. Well, you're not going to like my answer again, but my answer as a lawyer is, tell me more. Okay?
Yeah.
I know, I get it. I get it. I get the same reaction in my class when I teach it. But for example, the president has constitutional authority as commander-in-chief to kill what's called enemy combatants of the United States. Those enemy combatants can either, as Glenn knows, be unlawful enemy combatants without uniforms, or they can be lawful enemy combatants with uniforms. So we're probably talking about the political opponent possibly being an unlawful enemy combatant. If, in fact, that political opponent was an unlawful enemy combatant because he was part of a terrorist organization and he had threatened imminent harm against Americans before he walked down Pennsylvania Avenue, then yes, the president, as commander-in-chief, could order that he be shot, just like any other unlawful enemy combatant. But if he just shot that political opponent because he didn't like them, that's not part of the power of commander-in-chief. It's never been construed to be that way, and it wouldn't be. Okay. So that's a red herring.
Okay, let's give the audience more chance. Go ahead.
So we've heard a bunch of hypotheticals. Let me give an actual case. Watergate.
What?
All right, Watergate.
Watergate, yeah.
Right? So the president, the central charge against the president, for which he was being investigated criminally at the time he resigned, was obstruction of justice. And the central act that he committed was to order the CIA to interfere with the Justice Department's investigation of Watergate, citing national security or whatever grounds, right? Now, the president has the authority to control the CIA. The president oversees the Justice Department. Yep. Was he engaged in an official act such that we shouldn't have bothered about Watergate and he was immune?
Comment?
Yes, I think he was, as a matter of fact, because he does have control over the executive branch. And even though it was an obstruction of a judicial proceeding, right? And so immunity would attach, right? I'm not going to sugarcoat it. It would definitely attach. But the question would be, can we do anything about it as a people? Does the Constitution allow us to do anything about it as a people? Of course. Right? He could be impeached. He was about to be impeached, and he would have been impeached for that. So I'm not going to lose a lot of sleep over situations like that, because I'm hoping and I'm praying that the Constitution works the way it's supposed to work, which is that presidents get impeached for doing crazy things like that. We'll also never know, of course, because Ford pardoned him. Okay? So your real beef about that is more with the pardon, I think, than immunity, because immunity just never came into play.
Comment from you, Glenn, on the question?
Yeah. So I'm glad we just on this issue of specific instances, like the Trump cases. I actually think the Trump cases are pretty weak too. Not because I think the presidents are immune, but because I don't think that there's very good arguments that these laws were violated and that a criminal conviction could be obtained. But I'm treating President Trump there the exact same way I treat any other citizen if they're charged with a crime. And I don't think that a good prosecution has been brought. I don't think they should be prosecuted, not because he's special, but because I don't think that there's a good crime. But listen to what Professor Foley said just there in respect to the Watergate example, because it also relates to the one that I raised of not just the president telling the military, go kill that guy because I don't like him. Specifically in an insurrection, when he's invoking the Insurrection Act and calling a riot, saying use deadly force against the people who seem really critical of the police. Independent of what they're doing, those are the people you should look for. And they go and murder those people because the president tells them to. On the one hand, Professor Foley has a very broad definition of what the president's powers are. You just heard her say it. She said, even if Richard Nixon ordered the CIA to corruptly or improperly prevent the Justice Department from prosecuting crimes that were actually crimes because I'm the one who committed it, she said, sorry, I know it's not great, but his powers are so broad that he can even order the CIA to go do that. And this is how broad her perspective is, and a lot of people's perspective are of how broad presidential powers are, which means that within this huge, vast power that they have been given, you're essentially saying to them, if you believe in this doctrine, go and use that power. You don't even have to be careful. We're not even saying, oh, if you kind of get into some gray area, you'll be protected. What we're saying to you is, as long as you're using your proper powers that you really are yours, you can go wild, just wild out, go commit any crime that you want, be blatant about it, admit it, do it on tape, and you still can't be prosecuted because you're exercising the powers that really have been granted to you by the Constitution. And I go back to that example I said before. Judges have the power to issue verdicts. If they issue a verdict because they're wrong, they got the law wrong, of course they can't be prosecuted, just like doctors, if they make a good faith mistake, can't be sued. But if a judge exercising a verdict, which is their power, does so because they got a bribe, of course they can be prosecuted. They are prosecuted all the time. Same with members of Congress. So why should the president be any different? They shouldn't be. You can't find anywhere in the Constitution that suggests it, as I said earlier, and the message you're sending could not be more disastrous.
Next question.
So, Professor Foley, my question is, in the cases where the courts do find that the president steps out of Article 2, like the eviction and the vaccines, and in my fantasy alternative universe, warrantless surveillance, and they find he stepped out of his lines, is he then criminally and civilly accountable?
He's civilly accountable, yes.
And who enforces that?
The court.
Okay.
Any comment from you, Glenn? You want to pass?
Yeah, just quickly. I mean, Professor Foley talked before about things like torture and warrantless eavesdropping in violation of that statute I mentioned. And she said, well, there was never an adjudication. And it's true. The reason there was never an adjudication is because President Obama, following this political norm, although he campaigned saying, look, if Bush and Cheney committed crimes, they should be treated like anyone else. No one's above the law. Once he got into office, he said, it's more important as a country that we look forward and not look backward, even though every criminal prosecution against any other normal citizen, by definition, is looking backward. That's why we didn't get any adjudications on those, because even before the Trump case, as I said at the start, there was, unfortunately, this growing cultural and political norm that criminal courts are not for presidents, they're for everybody else. And that's what I think is so corrupting.
Next question. Go ahead.
My question is for Glenn, but it relates to one of the points that
Both of them going to answer the question. Go ahead. For Glenn. Go ahead.
So in effort of creating this balance between holding the president accountable for crimes that were committed, but also ensuring that political opponents of the president do not abuse that power, what type of framework do you envision to ensure that that balance is maintained and not abused?
What kind of...
Yeah, it's a good question. Like, we have a lot of models in law. For example, there's Good Samaritan laws, where we want to make sure that people who are walking in the street see someone having a heart attack who needs CPR but isn't an EMS worker or a doctor, doesn't feel like they should have to stay away because if they make a mistake, they're going to get sued. So we have a law that says as long as they act in good faith, even if they're wrong in how they did it and the need for CPR, as long as they were acting in faith, they can't be held liable. Like I said before, doctors, same thing. If they're operating and they make a mistake, as long as it's a good faith mistake, they're not being reckless, they can't be sued. To me, that would be the similar thing we should do with the president. Like, yeah, we don't want them constantly petrified that they're going to be held civilly or criminally liable so they can't do their job and they're constantly worried. But in egregious cases, I think they can't have immunity. They have to be prosecuted because we also want them in the back of their mind knowing if I really go too far, then I can be prosecuted. My big problem with this case and with the resolution and with Professor Foley's view of it is that, I don't mean to keep blaming her, she's just defending this position, is that what we're talking about here is absolute immunity. There are no exceptions. If the president's exercising their powers, no chance of prosecution, period, end of story, even as flagrant as it might be. And that's, I think, the problem. You could do a workable solution where you still allow them to act confidently, to not be petrified that if they make one mistake, they're going to be held criminally liable, but still know that when they step out of the lines of what is really into what's really criminal, they're going to be treated like every other citizen.
Next question. I have a couple of responses to that, if I
may.
Okay. One is that that's actually the way the immunity works under the Trump decision. The court basically said there are three categories of possible ways of looking at immunity or whether a president has immunity. One is that if the president is acting within what the court called its conclusive and preclusive authority under Article 2, then the immunity would attach, period, full stop. So, for example...
Like pardons.
That's right. We've already talked about pardons. But in the Trump case, for example, they said Trump's interactions, his communications with the Department of Justice about electoral fraud and things like that were conclusively and preclusively within his Article 2 authority because he controls that branch, and therefore they didn't need to remand on that issue. But the second category is what the court called the outer perimeter of the court's of the president's Article 2 authority, and that is the gray area that Glenn is speaking of. And for that gray area, the outer perimeter, that's exactly what they did. They remanded, for example, with regard to Trump's interactions with Vice President Pence when Pence was acting as the president of the Senate in his role to certify the Electoral College. And the court said, yeah, we see that when the vice president plays that particular role, he's actually sort of more in Article 1 in Congress than in Article 2. And so it wouldn't seem to be an Article 2 authority of the president, kind of put pressure on the vice president in that regard. But the court said, but at the same time, it might just be that the president was trying to cajole the vice president into doing what he thought was the right thing. And presidents always do that with vice presidents. They always sort of pressure their vice presidents to act, in the team way. And so the court said, I'm not really sure. We're not really sure whether this falls within Article 2 or not. They said it's presumptively entitled to immunity because it should fall within the outer perimeter, but we're not really sure if Jack Smith is going to be able to rebut that presumption, and therefore immunity might not attach. So in those gray areas, we have to have sort of factual nuance and a final judicial determination as to whether or not the president is acting in Article 2 or not.
Right. But just quickly, yes, everybody agrees that if he's outside of Article 2, he can be prosecuted. Like I said, if he raped somebody in the White House, the fact that he's president, no one believes he's entitled to immunity because what he was doing had nothing to do with Article 2 powers. But when he's acting in the exercise of Article 2 powers under this theory, like presidential pardons, there is no balancing act. If he's if he's exercising Article 2 powers like pardons, even if he does something as blatantly criminal as sell presidential pardons and admits he did it or did it for bribes, no prosecution. It's an absolute immunity for anything within the Article 2 powers, no matter how blatantly criminal it is. That's what I'm saying in terms of it being absolute.
You're arguing from the conclusion that the pardon power is without limit. And my point to you earlier was, I actually don't know that it is without limit. And you can't say that it is either because we just don't have case law that says that. And the McDonald case that I cite suggests that there may be limits to the pardon power. So I don't know that. There's a lot of people who write a lot, says the pardon power is plenary. They use the word plenary, but there's no case law that says that.
But you said that. You said that when you said the court said on plenary are powers. And I said, you mean like pardons? And you said, yeah, like pardons.
Right,
that's the ultimate case.
No. But remember, my point was it's textually plenary, but there's plenty of times when the court goes beyond the text and implies limitations. So, for example, there's a lot of things in the Constitution that aren't mentioned. I mentioned separation of powers. The power of judicial review. The very power of an Article 3 court, of the Supreme Court, to declare a law passed by Congress as unconstitutional is implied. There's nothing in the Constitution that says that, and there's frankly almost nothing. This is a very tiny sentence in one of the Federalist Papers. There's not a tremendous discussion in the constitutional ratifying conventions. So is there a power of judicial review? Well, we've accepted it in Marbury since 1803, but it's not mentioned in the text.
Let's take this with the summaries. Give the audience a final question. Please ask your question. Go ahead.
This is mainly for Glenn.
Louder.
This is a question for Glenn. I know you worked a lot with Lula in Brazil, and he was put in prison for money laundering and bribes. And you worked really hard to get him released. And I didn't really know the details of that case very well, but if there were receipts showing that he was engaged in even a small amount of corruption, then I guess what was the rationale for working for his release from prison?
Can you repeat the question as you understood it, Glenn? I didn't follow it quite.
Yeah. So he was asking me about, I had mentioned earlier the case of Brazil, where 2 successive presidents, the previous ones, have been convicted for acts they undertook in office. He mentioned the case of the current president, Lula da Silva, who was in prison prior to his being elected. He said that I worked to get him out of prison. And so just to be clear, he was in prison. He got convicted of acts that he undertook both in office and out of office, corruption, money laundering. There was no immunity. He didn't raise immunity. He got convicted. He went to prison. We happened as journalists to get a leaked archive of the internal communications of both the judge and the prosecutors who worked on that case and others that showed a lot of judicial and prosecutorial irregularities and even corruption. They were conspiring with one another in secret. They were far exceeding what the limits of their office are. And when we could show that, the Supreme Court reversed the conviction and said that because of this judicial impropriety, the conviction is nullified, but it didn't mean that he's exonerated. It's now sent back to the first level of court, and he's still subject to being criminally prosecuted. So I didn't work to get him out of jail because I believe presidents are immune. I always said if he's guilty, he should have a fair trial. The problem is what we were able to report showed he didn't get a fair trial, and so the court nullified it for that reason.
Comment from you?
But that would have been true for
okay.
any other citizen as well. And it actually was true for non-political officials as well who were convicted as part of that same probe.
Thank you. That concludes the Q&A portion. 5 minutes of summary from each side. The affirmative goes first on the summary. You can take the podium if you'd like, or you can do it from your chair. Either way.
I've gotten so cozy in this chair, I'm just going to say.
Fair enough. Okay, take it away. 5 minutes of
It's
summary.
the end of a long day. All right, so I don't want to spend a lot more time. I think I've made the Supreme Court's position clear. Again, I'm not saying I necessarily agree with the robust vision of Article 2 that Glenn thinks I agree with. So I think if I were a judge, I would probably be somewhat parsimonious in the way I construe Article 2, just like I would be with Article 1 and the powers of Congress. But a lot of the powers of the presidency have not yet been fully explicated by the Supreme Court in its jurisprudence. So there are still, in 2024, a lot of questions about whether the president does or does not have Article 2 authority to do this, that, or the other thing. And a lot of the reason for that, as I mentioned before, are standing impediments. So we may never know some of these questions, like the scope of the pardon power, as I suggested. And that's just the way our system works. But having said that, the specter of immunity for a president who undertakes official acts is not something that keeps me up at night. Because it presupposes that he is doing something that Article 2 tells him he can do. Our supreme law, our social charter says he can do it. And if he can do it, I don't want some statute to come along and say he can't do it. That just is not the way supremacy works. And Glenn suggests, well, maybe we could just pass a statute, kind of like the Good Sam laws, and say, well, if you act in good faith, we'll give you some sort of qualified immunity, and maybe you'll be immune and maybe you won't. But the problem with that is, it sounds good on the surface, but it would, as a lawyer, I can just tell you, it would be jet fuel for lawyers. It would be jet fuels for lawyers who don't like what the president is doing pursuant to his Article 2 authority. If you don't like lawfare, if you think lawfare is bad for this country, then get rid of immunity by all means, because it'll be, a field day for lawyers who want to sue the president for his official acts. And the bottom line is, even if we had a qualified immunity and if the president, won and was entitled to that qualified immunity, it still would be subjecting the president to sort of incessant litigation and criminal prosecution by people who don't like what he's doing pursuant to his constitutional authority. And the process itself is the punishment. The ability to bring the suits, whether it's a criminal prosecution or a civil case, just the ability to bring that suit and draw it out through discovery and through all the pretrial motions for years and years and years is the punishment. And it harms the presidency qua presidency. And I don't think that's what we want to do. And if we want to pardon, presidents sort of blanket, in a blanket style at the end when we think they may have done something wrong and some state prosecutors may come after them, I think that's fine. If that's the way the country wants to heal, that's a political decision by the incoming president, and I'm not going to lose sleep over that either.
Thank you. Glenn, 5 minutes of summary from you. Take it away.
Yes, I think we've had a very complete debate, a very spirited debate. I appreciate Professor Foley for that. I really enjoyed it. Just a couple points I want to emphasize at the end, a couple of key distinctions. About the Trump case and what it did. It is true the Trump case said, hey, there's some gray area here, and we want to send it back to the lower courts to determine what the answer is. But they didn't say there's gray area in terms of whether crimes were committed or whether a president can be prosecuted in the exercise of Article 2. What they said was there's gray area because certain things he did, we know he has the Article 2 authority to do. And other things that he did may not be Article 2, may not be Article, or maybe not be Article 2, maybe more Article 1, or maybe not even anything. Like, it just as a candidate calling a state and saying, can you find some more votes? We're not sure that's the exercise of a president. When it comes to the things that are within the Article 2 power, and this is the key, as long as it's within the Article 2 power, meaning someone is doing something that, as Professor Foley said it, they can do it, meaning these are powers this office has, the immunity is absolute. It's absolute. There is no possibility of prosecution under this vision, under this framework, which again has no basis in the Constitution, contravenes what the founder said. And I think it's so important to realize that. If it's within the powers, then there's no prosecution. And the reason why that's so dangerous is, again, look at judges, you look at members of Congress. Judges, as Professor Foley's phrase put it, they can do it. They can issue verdicts. That is what they're supposed to do under Article 3. That is what they're required to do. They issue verdicts. But nobody would ever say that as long as they're exercising the Article 3 power, they should never be held criminally accountable if they do it criminally. If they issue a verdict because they have some hidden stake in the case, or because they've been bribed to do it, or they're benefiting in some way. And we have held judges criminally liable for those things. Some are sitting in prison, and yet judges do just fine exercising their powers because it's not that hard to avoid clear-cut criminality. Same with members of Congress. Members of Congress can introduce bills. They can exercise oversight over regulatory agencies in the executive branch. We all think they can do that. That's Article 1 power. But if they do it criminally, for any of the reasons I just said a judge might do, they can be and have been prosecuted. And of course we want that to happen because we don't want to give judges and members of Congress the right to commit flagrant crimes and say as long as it's in the exercise of their powers, they get to be something that no other human being in the country is, which is somehow immune from the criminal law and residing above it. And there's no reason presidents should be either. So the last thing I just want to say is, as I've tried to say, this whole idea of immunity is so new. And I really do think when I wrote my book about it in 2011 called With Justice for Some, where I argued the damages being done, it was really prompted by President Obama's announcement that no matter how flagrant the crimes were in terms of warrantless eavesdropping or torture, we were going to give immunity, as he put it, to everyone in the CIA, the NSA, on the grounds that we should look forward and not backward. No other citizen gets that. Right? If you commit a crime, I promise you the state is going to look backward to see what you did. They're going to talk about your past acts in court. They're going to put you in prison for it. But politically and culturally, the idea became we shouldn't do that for presidents. And it all started with Richard Nixon. We let his attorney general go to prison. We let his White House counsel go to prison, his chief of staff, his top aides, everyone except the president. We said, no. We can't have presidents in criminal courts and prisons. We don't want that. That's for everyone but the president. They placed him above the law through the exercise of a pardon, and then it became the cultural norm. And then we had a series of clear-cut criminal scandals or serious scandals like Iran-Contra, like torture, like spying without the warrants required by congressional law, FISA, none of which got adjudicated based on this cultural norm that we don't put presidents in the criminal system. That's for all the other plebes and the peasants, but not for presidents. And so this criminality has accelerated. And though I'm not impressed with the Trump prosecutions, the fact in this case is the precedent of this case, it doesn't just apply to the Trump case, it applies to all presidents going forward and backward, is that as long as it's within Article 2 and they're doing something that the Constitution under Article 2 says they have the power to do, they can commit all the crimes they want and they'll be completely immunized. And now it's a formal codification of what had been a terrible cultural and political norm. And that's why I'm so opposed to the resolution that says this is helpful to the proper functioning of the executive branch. I can't think of anything worse for the proper functioning of the executive branch than giving every president an automatic get-out-of-jail-free card as long as they're exercising power under Article 2.
Thank you, Glenn. And that concludes the final summary. I have in my hand the Soho Forum Tootsie Roll that goes to the Oxford-style winner. Jane, please open the voting. Presidential immunity for official acts is a key factor in the proper functioning of the U.S. government's executive branch. Yes, no, or undecided on the resolution. While you're voting, I want to again invite you to come to our party afterwards. There will be a promotion once again from the Orchard Hill people. This intoxicating cider will be served in plentiful supply. You're supposed to pay for our parties. If you didn't pay, crash the party anyway. Sohoforum.org first thing tomorrow morning and give us a huge donation to make up for your sin. We would like you all to come, and Professor Foley, will you attend? I will. Okay, Professor Foley's going to be there. Yeah. Right. All right. Glenn, looks like you can't make it, but we'll hope to see you soon. I want to announce as well, not just about the party, but that, again, the Soho Forum offers a debate 12 months of the year. We are unfortunately not going to be able to be in the Sheen Center for the next 3.5 months. They're putting on some kind of special continuous show. But we will be at the Caveat, which is a little further east of here, and we will be debating El Salvador. The whole issue of the plummeting crime rate in El Salvador hasn't been good, hasn't been bad. That will be at the Caveat in late January. In February, we were going to make another attempt we are in the midst of getting pretty close to the attempt to do a debate on a college campus. We did succeed in having one at NYU pre-lockdown. We've been having increasing difficulty getting colleges to do debates. I will tell you that the El Salvador debate was supposed to take place at a college that decided it was too controversial to debate. However, we are now close to getting Dartmouth, of all places, to sponsor a debate about Israel-Palestine featuring Scott Horton versus Eli Lake. And that will be in February. And anybody will advertise it. Anybody wants to drive the 4.5 hours up to Hanover, New Hampshire in February, we'll register you and we'll get you free tickets, although obviously you're going to have to pay for your bed at the Hanover Inn. But that will be at Dartmouth, most likely in February. We're very close to getting Dartmouth to agree to do this debate. So we're excited again that we finally are getting at least a college to consider that debates are not a bad idea, and that the open forum of ideas is probably nice for college kids to be exposed to. In March, once again, we won't be able to be at the Sheen Center, but we're going back to the Soho Playhouse, which is west of here, and we're going to have a reception at the Torch, and I forget what it's called, a very good restaurant right across the street. This will be Israel-Palestine, an issue we're going to return to, and it will feature Peter Beinart, who's written a book about the subject, and we'll have a book coming out in January, and we'll be doing book signing and sales. At the moment, our January debate is listed. Our February and March debates will shortly be listed on our website. Once again, please come to the party, and I think I see Jane approaching me with the results, which will tell me who gets the Tootsie Roll from the Soho Forum. And I'm reading this. Okay. The yes vote began with 33.3%. Sorry. Okay. I'll start again. Thank you all for correcting my amateurist, and I will read the results. The yes vote went from 1/3 to 32.3. It lost slightly, a little less than 1%. The no vote went from 36% to 55%. It gained 19 points. Therefore, the Tootsie Roll goes to Glenn Greenwald. Glenn, next time.
All right, I'll look for that. I love those Tootsie
Next
Rolls.
time you're passing through New York, I will leave this with the hotel clerk. I know that you value Soho Forum Tootsie Rolls, and so
Absolutely.
guaranteed this will be yours when the time comes and when that knee of yours heals. Congratulations, Glenn, and congratulations, Professor Foley. What? Professor Foley, you're in Florida. You won't be able to get it to him. Won't work out. That you spent a lot of time in New York. You'll probably be back here. You'll get the Tootsie Forum Tootsie Roll. Thank you to both of you for an excellent party very shortly. Bye-bye, Glenn.